that once a person is within custody, the question of a further arrest always does not happen, and that your lordships has explained in 4 judgments at least. And I can show that. But what is the procedure there?
Other cases always can happen.
It can happen, but it will be shown. He will still be. I am not wanting. I have said that in my counter that judicial custody will just continue vis-a-vis that case also. That's about all. That is what 267 CRPC, if your lordships have a look at it, that is what it provides. So therefore, my lord, I am only saying, my lord, that insofar as that is concerned, and there are judgment. So, I am with all humility, I say, your lordship's observation that we should await the judgment, my lord, would be the right course, my lord, is what I am submitting respect.
Then I don't, not I really.
No, then,
No question, not the overall
in
understanding.
custody,
Yes.
you can examine or whatever, but
And interrogate.
interrogate. But then
No, my lord,
formal arrest is
for that, my lord, I would, for purpose of interrogation, I will need your lordship's permission, because otherwise, my lord, because I have filed the warrant under 267 for the purpose that I can show him in my custody, then only I can apply for police custody. I can't apply otherwise under 167. So therefore, if your lordship permit me that I can interrogate.
saying is that for interrogation you will have to detain him in this particular case.
Yes, my lord.
But that's, I'm sorry, that's
That
completely
is
malicious. It's a,
subject to the orders of your lordship.
but actually, not, it's a complete misrepresentation of the law. I'm sorry to say this, but he's been in custody now in the first case since 9th of September. They have not bothered to go touch him till now. They've not even asked a question once.
Tell you what the judgment.
No, but may I just, no.
1 minute. We are fixing it on. We're fixing it on.
Should be the memo they filed.
7th. Now this is a bill anticipatory 8th November.
No.
Let the understanding continue.
Yes,
Please, I understand. I'm
List on
just making, if
November.
I may make one,
2023.
but if I may make one submission, with subject to your lordship judgment. This is that the application for this purpose before the trial court was already there. And if not, and
Mr. Kumar, he is in custody.
please, lordship, please. Lordship, 8th November.
8th November.
Lordship, please.
but would 9th be possible? Or?
9th, okay, 9th, because it's the bail matter, it can come on any.
Yes, it can come on any day. Lordship, please. Great. Great.
Wait, please. This is an anticipatory bail application which is very summarily rejected if you see the impugned order.
The allegation,
Just see the background because we
Very
are
murky kind of thing.
no. So let me unmark it for you. Just if I can just show this, just
According to you, it is a counterblast.
it is a little more than a counterblast because this man is an advocate. I'm just giving the background.
Maybe anything.
No. The person who has filed the complaint against me is an advocate. Now, we are two legal interns who are working for another advocate.
Oh,
He is having a matrimonial dispute.
still they are interns and they are indulging into this kind of
Just see the back. See the back.
like advocates.
This is completely false. There are two affidavits filed by the two victims saying it's false. Just see the background.
Kind of allegations.
No, I can only invite you lordship to just see what I've taken some time to put this together. Maybe you can at least look at it. These are the previous cases
Yes,
against.
we have gone through all this year. They are there.
These are the previous cases which are filed against him by his wife and daughter, whose lawyer's office I work in. All of this is listed. There are two complaints to the Bar Council, not only by these people, but by other clients also were disturbed by his behavior. Finally, on 27 July, at the bottom of that page,
That doesn't mean that you are innocent.
am I saying I'm innocent? I am saying for an anticipatory bail
If
state.
you have not indulged into this kind of Then one will-
Anticipatory bail, somebody will argue innocence.
That's what.
I'm not going to argue innocence. It's anticipatory bail.
Anticipatory, that's what.
That's all it is.
Anticipatory bail can be granted only when
So
prima facie you satisfy that you are not.
that's what I'm trying to do, but your lordship will at least take a look at what I'm saying. There are 14 allegations against that man.
There were CCTV cameras, you try to.
And there are just see page 68 of the IA. Of the IA, just see page 68.
19560 again.
There's only one IA.
Which idea?
There's 219560. That's the IA we have filed. These are the witnesses to the so-called incident. Page 68, annexure P7.
We haven't got the IA.
219560. No.
Yes, 219560.
IA is not on record.
Just do you have copies?
It comes into 9 pages only.
No, it's a fairly lengthy 78-page IA for editorial document. Please give hours. Do you have?
Then it come on the reopening date, please.
Very well. Just we make sure that it's on record. Then I'm sorry that you don't have it because there are
A list on.
two affidavits filed.
No, not.
That's
Theme 1. 78 pages.
that's. Now, if your lordship have not had an opportunity, then reopening is fine.
Reopening.
Very well.
List on the reopening. Here.
11.
Make clear, madam.
Grateful.
Yes.
Was the interpretation of section 29 and also 14 of the Limitation Act. I was prosecuting the proceedings therein before the family court, who are the judicial proceedings therein. And I only wanted to take the plea that yes,
So within 1 year, you will have to.
and I filed only in 15 months. Earlier to this, I filed the petition for judicial separation.
Yes, you filed another suit for
Yes, madam.
separation. That was
filed with the,
that was business, and simultaneously you filed this also.
no,
For an
it was filed afterwards. What is that?
How many multiplicity?
I filed the proceeding therein under section 10 of judicial separation that on account of the conduct.
We are not interfering.
My lord, can I say, my lord, this is a case with here my life has been spoiled. My lord, can I take the only two minutes?
Every husband will say that.
My lord, I have been knocked out only on the limitation, my lord, not on merits as such. Had it would have been on merits, I would not have come. And I would not have convinced also. My difficulty is,
Ground you could have taken in first suit also.
my lord, in first judicial.
You filed first suit saying that she is my wife, legally wedded. And
I'm not.
this.
No, let me.
Now you are filing saying that I am seeking declaration on the ground of.
Well, let's see. I'm not disputing those facts. I'm accepting the facts. I'm saying that 17th of June my marriage there. On 17th of October the 4 months thereafter.
Dismissed, point of law kept open.
My lord, it is covered with my lord judgment there in 2022. My lord, can I have only a minute? My lord, paragraph 22.
We are not.
We also have some judgments.
My lord, I'm citing my lord's own judgment there too. 22 judgment is there which says that yes, Hindu Marriage Act limitation will be there from regarding the original proceedings. That's why the interpretation given by the High Court is wrong. Because my lord has already said so. Well, I'm only saying, I'm only
We are
saying,
not interfering. Yes, next matter.
I'm honored.
Later. Next matter. Adjourned. Right.
My lords, the petitioner applied for the position of
See, those selected got higher marks. That is the finding.
correct, my lords. But kindly, I would like to bring your notice to page 20, the appointment letter which he received, which the petitioner received. In page 20, annexure P2. He received this appointment letter where he was intimated that he was selected for the position and he was required to furnish his documents for verification. And he very much obliged to that, and he appeared before the concerned authority.
Merely because you are in the select list, that doesn't give you any right of appointment.
Please, my lords.
That is always subjective.
But still, my lords, he should have been given an
It has
opportunity.
been examined by single bench, division bench.
This is not an appointment letter, it's a selection letter, dismissed.
Right.
What do you mean?
Interpretation.
For the 14, ma'am.
Yes?
My lord, the
Why are you
presentation is,
showing?
no, my lord, just a minute.
Clean.
It's what showing 13. For that reason, I was standing by.
Oh. Yeah.
Apology. My lord, the present petition is very much restricted to the section applicability of section 29.
There is a concurrent finding. That should be interfered.
My lord, in the concurrent finding is with respect to the applicability, but in the initial in the trial, the basic nature of the property was being taken as a self-owned property, which was being later being clarified as the ancestral property. If in the basic trial, at the stage of trial only, the same provision or the
All
same.
have been given 1/6 share.
Yes, my lord.
All have been given 1/6 share.
My lord, as per the section 29, if the marriage is prior to the 1994,
No.
then the
Courts are exempt.
Dismissed.
Grateful, my lord.
Wait, please, my lord. My lord, it's a case of a reversal by the High Court, my lord. What has happened is, my lord, the widow, she adopted, my lord. And thereafter, my lord, he was the only person who was there in the family.
That had money.
Notice.
My lord, please kindly grant the stay of the High Court because I am in the possession of the property, my lord. He has not said it in his favor, my lord.
Notice.
No,
Status
my lord, can you see
Status quo.
status quo, my lord?
notice until the next date of hearing, there shall be status quo as on date, as far as the subject property is concerned.
Obliged, my lord. Deeply obliged, my lord.
Still there is a letter.
yes.
Letter.
The petitioner is wife seeking transfer from Fatwa to.
Declared petition was dismissed earlier.
How many times will you fight over the forum? Dismissed.
Yes, sir. Yes, sir, on the basis of the plaint itself, what happened was with the will.
Only 711 application has been rejected.
But this is the ground. We have to
be
That can be.
that is the other. So, kindly give me 2 minutes. Page 58, kindly have for a moment. From where they are entitled.
Because the suit is barred by family settlement or not. That
No,
can be-
that is not an issue.
Never.
That is not an issue. Issue is that the basis of the filing of the suit, which is will, that is unattested. So the person,
That can be contested in the
63,
711. You know,
63, kindly. So that
interfering as a matter of
there are
rejection or allowing.
kindly have
Allowing 711, we may interfere. But
kindly have 2 minutes.
we have a chance to contest in the.
That is not the case.
There is no point of law.
May submit 2 minutes.
Sorry.
2 minutes.
Fall under any of the clauses of 711.
We fall. I'll convince you. We fall. Otherwise, I would not have come to the court here.
No.
Kindly have 2 minutes.
Anyway, order 711 rejection, it should have come to the court anyway.
The suit is not barred.
So barred by the law, the basis of the suit, that is the will, that is unattested. Their basis. This is not my basis. And in the plaint itself, along with 711 and 714, the document are missing. A direct judgment I have. Basis for documents that the 711 was allowed.
The moment you invite the court to enter into that question, 711 goes.
No, you also 711. Within the parameters of 711, kindly have two documents, they will kindly have.
Sorry, next matter.
Please, Your Lordship. Kindly see Your Lordship's petition.
You challenge show cause notice.
It is kindly see section 23 is with regard to can
So all notice has been held to be valid.
no kindly see why it is.
We are
Kindly
not
see section
interfering.
23 says
The luxury litigation, we are not interfering. Dismiss.
23 says it should be transferred. She says fraud has been committed. How she is covered under section 23?
You answer the notice.
You also that notice.
You are.
Quick correction. The reduce the office report. Direction as paid for is given. Let in this direction as paid for is given. CBN fact is
This one has to deposit additional 25 days.
We are waiting for this comment.
we saw the
Exactly. Well, I pay for the petitioner. This is the case where the question of whether this is ancestral property has A been sent back. Number two, your lordships will also
isn't
see.
that a question of fact?
No, the point is, it goes to the root of the question. If the ultimately the fact that the property is ancestral has been sent back.
A factual issue can also go to the root of the question, but whether Article 136 will invoke or not, that is the question.
Three points. Well, your lordships are right. It is a suit for specific performance. Well, the finding is, in the first instance, one of the property worth 15 lakhs is supposedly alienated by the head of the family.
But they have been direct by additional 25 lakhs.
Yes. Well, and your relation will see the property is worth 5 crores today. I have effectively been told to part with it, where the question of whether I am an owner or not itself is.
The price is bound to accept.
That your leadership is right, but my ownership itself has been remanded back. Number one. Number two, please see, the plaintiff does not step into the witness box. It's a curious case where the plaintiff's readiness is not established. The finding is that the plaintiff deposits money after the decree. So, barring a simple averment, not a piece of paper to demonstrate actual readiness and willingness, well, a legal notice is issued.
That has been examined by both.
Some factual.
Your lordships only consider the other matter, where the issue between the parties is before your lordships. That is coming up. If your lordships would only consider issuing notice, I am not asking for any interim protection as well.
Oh, there's a separate matter. It had nothing to do with this one.
Which other one?
His son has filed.
The son. That's for the point. The son had filed a petition.
In order to defeat our degree, the son has been
No, I'm so sorry.
Examine
That's the point I'm making.
his claim
independently.
would like to.
Dismissed.
23 and 24.
Lord, these are item 23 and 24 are the need to be tagged with that bunch of their identical.
Why so many cases are?
Lord, all these people have been terminated without notice. Lord, these petitions were listed yesterday before your lordships was supposed to be listed, but because it's a miscellaneous week, I think they were not listed and the date is not been given. So I'll just pass on the order, my lord. This is the last order in that bunch of matters. I submitted maybe tag.
Tag with it, huh? Issue notice.
Yes, my lord.
Tag with what is the main appeal number?
Gopinath Banjo, my lord. It's that 2419, I think.
Tag with
2419 and 2420 of 23. Gopinath Banjo's case.
2419.
So slow.
We only see numbers.
My lord, it's the lead matter is Gopinath Banjo, which is 2419.
Matter is showing to be Achinta Kumar Mondal.
Lord, that is just the order passed in Achinta Kumar Mondal. But anyway, my lord, the whole bunch is the same. My lord, we tagged it with Achinta Kumar. Same
List along with civil appeal number
2419, that is
2419 of 2023.
obliged.
There is another matter also.
My lord, it's the same. 23, 24 are identical.
24.
Just different petitions.
Notice.
25.
Those connected matters, my lord, your lordships have been pleased to issue notice.
Yes.
In fact, those connected matters, my lord, are also listed today after notice. They were mentioned at item 65.
Okay. So
They may have to be posted on an NMD, my lord. The lordship issues notice and
When the other matter has been kept
my lord, today at 60, item number 65 before your lordships.
but that is
by the state.
Same matter, yes, by the state, my lord, in a different, in respect of different party.
so shall we pass? That's fresh matter.
No, that your lordships have been.
65 and this both to be posted some after
That's my but I must point out, my lord, the petition, the respondents in that matter had mentioned the matter, therefore 65.
Okay,
We have-
we are right now passing it.
So he may have an urgency, that's what you are saying?
Possibly, my lord, because they had mentioned in 65 They may not. I'm not sure because they had mentioned and gotten it listed. So they may not be aware that I'm making this submission.
Somebody else.
That will be better because it has been
taken in 65.
This matter in any event, your lordship may have to issue notice.
Let it come. He'll take it.
Right.
26.
It's a correction of decree.
Sir, we have not
Order
given
22 rule for application was allowed,
Sir,
but their name was not included.
Your Lordship, can I say one thing? The order says no need to issue notice to me. This court is also hearing me. Any order partem is the principle of natural justice. Under 227, the High Court has said it falls and this judgment is applied. It is not a power under appeal. I can understand if I am in appeal. I should have not come here. But under 227, there is no hearing has been given to me. P9 is very clear, where it says there is no need to issue notice to me.
Now, what do you have to say? Tell us now.
Your Lordship, then again, the things are that if I have not been given any chance to appear,
About this, this substitution application was allowed. But in the decree, the substituted whoever, judgment
I was also prejudiced because I have filed Order 9 Rule 13. In this order, the court has also observed that on the next para, on 1st November 2009.
So Order 9 Rule 13 will remain.
Sir, I am saying the court is observing with regard to the fact these two LRs, including me, have been served. So there is no prejudice. Ultimately, that court is listening my 913, giving its mind in this case. So how I will get a fair hearing from the court? That is what I'm saying. I should be heard.
If you don't get it.
That is why I'm saying this is a case where Manika Gandhi, as a student of law, I have understood that order partem is the natural justice.
When you're arguing before Supreme Court, you are an advocate, no more a student of law.
Sir, I can't say anything.
So that we are also.
No, I'm not saying that.
We are also students of law.
I
But
only
please
say
tell us.
Give one opportunity.
In real terms, how are you aggrieved by these orders?
Your
Which
Lordship,
has only corrected the.
Lordship, kindly see my application under Order 9 Rule 13. I am not on that. His stating therein that kindly see that order for a moment.
Prejudice is caused as such.
The Lordship, if the appellate court will decide all the things.
Let 913 be examined on its own matter.
What we may observe that notice ought to have been given, but since no prejudice is caused to the.
And my application under Order 9.
We are not interfering with the order. The order. Putting aside ex parte decree, his application shall be taken on its own merit.
Yes, this is my only grievance. Oh, nothing more. But that should come. At least the trial court should hear this is.
No, is there any observation about your Order 9 Rule 13?
Yes, no. Observe regarding my appearance.
He states that petitioner has filed an application under Order 9 Rule 13 before the trial court. Any appearance that is their observation in the order of 5 will prejudice the petitioner during the adjudication of this application.
The High Court has also observed that 913 will be decided on its own merits.
But it is not in. The High Court said, High Court records my everything, that as if I have to give the everything.
Intended to do the same thing.
I am saying High Court is recording everything. My other grievances also there. I have not been given chance
to know. But on your other grievance, it has not adjudicated. It has adjudicated only on this correction.
Your Lordship, the trial court.
We accept that.
Your Lordship may observe this only and dismiss my petition. I have no issue. At least a message be given to the trial court. They should not pass by. We are coming. We are burdening our clients with this cost, etc. and these courts.
The petitioner assails an order.
And what are
sorry, the petitioner in substance asserts an order by which the High Court, by which the trial court had directed correction of decree by incorporating therein the names of legal representatives of
the deceased respondent number 1.
no, defendant.
Yes, deceased defendant number 1.
Of the deceased defendant number 1. The petitioner accepts that an application under Order 22, Rule 4, prior to the passing of decree was allowed, and the substituted legal representatives were brought on the record. Stop. The petitioner's grievance is that he was not heard while the correction order was being made. Stop. It is also the petitioner's case that he has filed an Order 9, an application for setting aside the ex parte decree, and that matter is pending. Stop. We are of the view, the High Court in its superintendent jurisdiction in 227 or 100?
Yes, 227. 227.
High Court in exercise of its jurisdiction under Article 227 of the Constitution of India has sustained that order. The petitioner's only grievance is that he ought to have been heard. We are of the view that, we agree with the submission of the petitioner that a hearing, he should have been given an opportunity of hearing, but the order in substance does not cause any prejudice to him, as it is merely to